Right. Well, hello, everybody. I'm Stephen Hockman, Head of Chambers at Six Pump Court, and it's my pleasure to welcome you to this webinar on the subject of solar salt projects in Africa. As you can see, I'm joined by our three speakers. First of all, Stephen Walker QC, who is a very experienced international arbitrator and also practices as an advocate in international arbitration. You will also be hearing from my London colleague, Chris Badger, a specialist in environmental and regulatory law and a star of the junior bar. And thirdly, we're particularly pleased to welcome this morning as our guest and as our additional speaker, Professor Colin Roberts, a very experienced petroleum and mining engineer who in more recent years has developed a highly successful career in what might be called the field of dispute resolution, acting as an arbitrator, a mediator, and generally assisting people in that sort of area. Each of the speakers will speak for about 15 minutes. You're more than welcome, I was about to say, to put your questions in the Q&A box as we go along. And we already have a question, which is of a fairly general nature. The questioner says, will the recording of this webinar be made available afterwards? To which the answer is yes, it will. So you will be able to listen to it as many times as you like hereafter. But I'm hoping that you will nonetheless stay and listen to us during the actual live performance. As I think I was about to say, each of the speakers will speak for about 15 minutes. Then there will be a question session, and the more questions you put in the Q&A box, the better. That will enable us to have a lively question and answer session towards the end. I guess we'll finish at around midday or maybe a little after that, depending on how many questions there are. There will be a recording. We may well send around one or two papers after the event so that we can keep in touch with you, and we'll certainly be delighted to welcome you to future events as well, and we'll keep you posted on those. But I think with those introductory remarks, I will now hand over to Professor Colin Roberts to give the first presentation. Colin, over to you. You need to unmute yourself, Colin, if you would.
I'm known as just Col, so not Professor Colin Roberts, and it's COL for Colin and not for Colonel. So I'm Col Roberts. But I'm going to give you a snapshot, if you like, of a project that we're working on in East Africa. And in fact, it's on the Horn of Africa. And it's a solar salt project, as the title suggests. So the name of the company is Salturnus Limited. That's an Australian unlisted public company. And we have a fully owned subsidiary, Salturnus GmbH, in Germany, and which is actually the organization or the company, the identity that is dealing with East Africa. So let me just tell you a little bit. We'll go through point by point, and just to give you this, if you like, snapshot. One moment. Okay. So the vision is it's going to be the world's largest solar salt producer. It'll be producing in 2025 5 million tons per annum, and increasing up to 13 million tons per annum in 2030. As a byproduct of the solar salt, we'll also be producing sulfate of potash, SOP, and it's an through an energy efficient process, and it's really a byproduct of the salt production. Normally, this salt is this SOP, or the byproduct, which is called the bitters, is just pumped back into the sea. So it becomes a little bit of an environmental problem. So we've come up with a system whereby we can actually harvest the sulfate of potash and produce about 125,000 tons per annum, increasing in 2030 to 228,000 tons per annum. So, you know, there's a third part of it, and I'll talk about that just a little later. But what it does for the area that we're in, we are going to create a national economic growth and well-being, leading to a reduction of poverty and subsequently the reduction of conflict. Now, where is it? It's in Somaliland. And where is Somaliland? Somaliland is the westernmost province of Somalia. And Somaliland is a self-declared independent state. It has its own parliament, it has its own police force, it has its own army, it's got its own economy and so on. It's been in this limbo for probably the last 20 years. And in fact, at one stage, they were actually at war with Somalia itself. Well, now everything's settled down, it's been very quiet, and now it's quite a peaceful place. In fact, it's 1,400 kilometers away from Mogadishu, which is where the trouble spots have been. Anyway, that aside. So we have in Somaliland, keep Somaliland in your mind now, we have a 25-year renewable agreement for the lease of sufficient oceanfront land between Sultanas, the company, and the Ministry of Investment and Promotion of the Republic of Somaliland. Now, we have completed a scoping and feasibility study just late last year in 2020, and we are just starting now an economic and technical definitive feasibility study, which should take about 12 months. Now, of note, this project is a non-speculative engineering and production undertaking with a perpetual natural resource. Therefore, there is no uncertainty or requirement to prove up ore reserves as with the traditional mineral exploration projects. Remember in the introduction, I'm a mining engineer and a petroleum engineer before I actually drifted away from that field. So let's have a look at the project economics. Well, the price of sodium chloride salt is current prices is US dollars, all the dollars are US dollars, is $42 a ton. Of SOP, which is a sulfate of potash, it's $600 a ton. And there's a food part of this project as well, which is also valued, we've estimated at $600 a ton. Now, the project life is 25 years, plus a further 25 years, plus a further 25 years, you know, for as long as we can. The gross revenue of this project is $14.5 billion. That's over the next 20 years. So it's about $737 million per annum. The NPV is probably is 3.4 billion US dollars, and the internal rate of return is 31%. So what we've expended to date on the pre-feasibility is just over 3 million US dollars. So we're now, as I say, going through the definitive feasibility study, and we should be, you know, starting to construct the project in about 12 months. So we're looking at producing 13 million tons per annum of salt, 228,000 tons per annum of sulfate of potash, and food 150,000 tons at a cost of about $12 a ton. Now, I want to go into really what I wanted to talk about. Well, sorry, well, I'll do the food part first. The third stage is the construction of desert greenhouses covering an area of 5 square kilometers. And it takes advantage of the fresh water that's generated through the solar evaporation. So producing 140 kilotons or 1,000 tons of fresh food every year, it'll be a commercial operation paid by the project, if you like, handed over to the government. Now, annually, 6.2 million people are suffering in the Horn of Africa from lack of nourishment. Overall, some 388,000 acutely malnourished children are in need of critical nutritional support. So, and including a life-saving treatment for about 87,000 of these. So the food production will be available to the population in times of famine. So it means that we're more or less trying to eliminate famine in that part of Somalia. So we're looking at Somaliland. So, but at the rest of the time, the government will be able to reap a revenue of about 1.7 billion, or $84 million per annum. So let's get back to Somaliland. This is what this talk is about, really, is a major project in a difficult jurisdiction. Somaliland, as I mentioned, is a self-declared independent state, not yet internationally recognized, and it's known as an autonomous region of Somalia. The advantages to us are that it's a stable government, it's a safe environment, and of course, the seawater has a very, very high salinity in the Gulf of Aden, 36 kilograms a ton. And it's also close to major shipping lanes and an ideal climate for solar salt operations. Sovereign risk. Now, Stephen Walker will be talking about sovereign risk following me and about treaties and so on. But it's not unknown that Somalia is one of the world's most challenging operating environments in the world. However, in the autonomous region of Somaliland, it's comparatively more advanced with institutional capacity and rule of law that provides a more stable investment environment. And Salternus has applied mechanisms to mitigate such risks to foreign direct investor. Now, when you think of Somalia, let's not think about Somaliland right now, but when you think of Somalia, what do you think of? You think of Black Hawk Down, you think of pirates, you think of an unruly government and terrorists and all sorts of things, which of course in Somaliland is totally different. Very quiet, very, very stable. But the investors, trying to convince an investor to invest into the Horn of Africa, into Somalia, and even better, into Somaliland, is really a difficult task. It's a tough sell. So let's talk about now, how do we mitigate risks? The Somalia, as a sovereign state, is a contracting state to the Washington Convention. It also has a few bilateral investment treaties with some states. And this company, originally being an Australian company, well, Australia only has about 23 bilateral investment treaties. And only one of those is in Africa, and that's Egypt. There is another one, if you can classify it as Africa, and that's Mauritius. But anyway, let's just think of it that there are no bilateral investment treaties in the continent of Africa, excluding Egypt. So we looked at Somalia. Obviously, Somaliland doesn't have any treaties with anybody, but Somalia, and Somalia is the closest that we can claim, has bilateral treaties with a few countries, not too many. But one of the countries it has a bilateral investment treaty with is Germany. Now, prior to this investment, we set up a Salternus company in Germany, and we have people in Germany, so we have a German identity. And the German company, Salternus GmbH, is actually doing the contract in Somaliland. So we're protected there by bilateral investment treaty. We're able to go through international arbitration through ICSID, but also we have a development agreement with the government as well. And the dispute resolution clause with the government is primarily ICSID, should we have any sovereign risk problems. And if ICSID decides that they're not going to recognize or take on, be the right jurisdiction, we also have the LCIA as a backup. So that's what we've done initially. We've also had meetings with the Somalian government as well, so there's no problem there with us investing in Somaliland as far as Somalia is concerned. Then there's the Multilateral Investment Guarantee Agency. a section of the World Bank. The Multilateral Investment Guarantee Agency is willing to underwrite the project. It's not cheap because it's being one of the high risk areas of the world. I think the cost is about 300 basis points, so it's reasonably expensive. So on the sovereign risk, and I'm sure Stephen will have some words to talk about as far as the treaties are concerned. So the funding strategy, as I say, we've done the pre-feasibilities, and we're working through the definitive feasibility studies now. We've talked to project financiers in London, and we found a very, very good reception that they'd be willing to fund it. That's the construction of the project, and perhaps also joining that with listing in Frankfurt, the LSE, or perhaps even Toronto. But that's for the future. The timing, as I say, we'll be producing the 5 million tons plus the SOP in 2025, and by 2030 we'll be having the full production period there. I think that's all I've got to say about the project itself. So really, if we need to know any more, we can answer those in the question section. Thank you very much.
Thank you very much, Cole. That was fascinating, and for my part at least, I'm really pleased that in this particular webinar, and thanks to you, what we're going to be able to do is to look at how one strikes a balance between international and domestic law and regulation, which are the areas that the rest of us tend to focus on, and the need, which you mentioned, to encourage economic development, particularly in places like Somaliland, and how one strikes that balance. That seems to me to go absolutely to the heart of what one needs to think about for the future of the planet going forward. So thank you very much for your presentation. And I will now pass, as you foreshadowed, to Stephen Walker. Over to you, Stephen.
Well, thank you very much, Stephen, for your kind introduction. And very good evening, ladies and gentlemen. For me, I'm actually in Australia, in Perth, Western Australia, as I speak with you all. So very good evening. And I want to talk with you about how investment treaties can protect your investments and things you should consider before your clients make large transnational investments. Investment treaties are bilateral or multilateral agreements between states which assure a degree of mutual protection of investments made in one state, the host state, by investors of the other state, the home state. These treaties will contain protections against, for example, expropriation by the state and unfair treatment of the investor, which is enforceable by the investor through international investment arbitration. I first became interested in investment treaty arbitration 20 years ago when I was involved in the first ICSID arbitration under the Energy Charter Treaty, the case of AES against the Republic of Hungary. Now there are over 3,300 bilateral investment treaties, or BITs as they're called, in force, alongside a smaller number of significant multilateral investment treaties, for example, NAFTA, which is now called the USMCA, and of course the Energy Charter Treaty. An investor also needs to consider if there are any helpful foreign investment laws or investment agreements, for example, free trade agreements, which might also offer investor protection. In the early 2000s, investment treaty arbitration awards for compensation in the tens of millions of dollars, and like Cole, when I refer to dollars, I'm talking, of course, about US dollars. These awards were considered large. However, looking back, it seems rather quaint, because today, the largest award of compensation in investment treaty arbitration is the $40 billion awarded in Hulley against Russia. This was the largest of several related claims arising out of the nationalization of UCOS in which a total of $50 billion was awarded. There are now 50 known cases in which a tribunal has awarded compensation over 100 million US dollars, including 8 known cases where the tribunal has awarded more than $1 billion. There can be a vast discrepancy between the amount of money actually invested by the investor and the amount obtained in compensation. In Tathian Copper against Pakistan, an investor was awarded $4 billion plus interest for Pakistan's failure to grant the necessary approvals for the investor to build and operate a mine, even though the mine was never built. In Union Fenosa Gas against Egypt, a foreign investor was awarded $2 billion plus interest for Egypt's failure to supply an agreed volume of gas to the investor's liquefied natural gas terminal for export. Egypt, in that case, had argued the gas was needed for domestic consumption. These large awards can pose serious challenges for developing countries, but they can be a powerful tool in the armory for the investor. For example, the $4 billion award in the Tathian Copper against Pakistan case in July 2019 was almost as large as the International Monetary Fund's bailout of Pakistan that had been agreed 2 months earlier with the intention of saving the Pakistani economy from collapse. According to UNCTAD, the United Nations Conference for Trade and Development, as of the 31st of December 2019, the total number of treaty-based investor-state dispute settlement arbitrations had reached 1,023. Of course, this is only part of the story, ladies and gentlemen, because there will be many more than this, and there will be many more arbitrations that we simply do not know about because of confidentiality. Also to December 2019, 120 countries and 1 regional grouping are known to have been respondents in 1 or more investor claims. So the awards in investment treaty arbitration can be enormous. Let me give you a few examples. Hully Enterprises against Russia, $40 billion. ConocoPhillips against Venezuela, $8.4 billion. Veteran Petroleum against Russia, $8.2 billion. Tathian Copper against Pakistan, the one we just mentioned, just over $4 billion. Union Fenosa Gas, again, $2 billion. Yukos Universal against Russia, $1.8 billion. These sums are absolutely staggering, but it also demonstrates that investment arbitration can be a powerful tool to have up your sleeve. So don't forget to consider it, and don't forget to ensure, if you need it, you actually do have the ability to use it. Whilst there was a fair degree of international consensus and therefore similarity between the terms of these treaties in the 1980s and the 1990s, a greater divergence of terms has emerged over the last 2 decades. Each investment must therefore be examined on its own specific facts and the terms of the relevant treaties and so on, preferably before the investment is structured and made. There are 3 key issues to consider for investors in relation to investment treaties. Firstly, what investments qualify for protections? Secondly, what protections do the relevant treaties provide? And thirdly, how those protections may change. So firstly, what investments qualify for protections? When considering how to structure an investment to benefit from an investment treaty protection, one must carefully consider the treaties which apply to the location being considered for investment and the scope and application of those treaties. As a basic framework, though, the 2 issues in relation to scope are, firstly, is there a qualifying investment? And 2, is there a qualifying investor? Is there a qualifying investment? The treaties tend to cast a wide net in terms of what constitutes a qualifying investment, ICSID case law has interpreted investment in the context of the ICSID Convention to depend on the following 4 elements, although not all 4 elements are always required. These 4 elements are contribution of money or assets, certain duration, so not really short term, an element of risk, and lastly, a significant contribution to the economic development of the host state. In particular, for obvious reasons, the 4th factor has not been universally applied. If an investor is in doubt as to the qualification of an investment being made, but is dealing directly with the state or the state entity, it would be well advised to bargain for contractual protections and subject them to commercial arbitration. And in fact, we heard Professor Colin Roberts say exactly that in his own Somaliland case. Of course, this is just normal good practice, of course, and part of the bigger picture of mitigating risk and protecting the investment. Is there a qualifying investor? The scope of investors protected by investment treaties has been the subject of particular controversy in the context of the often complex investment structures employed. For the traditional BITs, mere incorporation of a company in the home state is likely to be enough. For example, in the case of Aguas del Tunare against Bolivia, US and Italian companies formed a JV incorporated in the Netherlands, which operated a Bolivian water company. The tribunal held the Netherlands JV was able to bring a claim under the Netherlands-Bolivia BIT. Another case, Tokios Tokeleles against Ukraine, a Lithuanian company was held to be a qualifying investor to sue Ukraine, even though 99% of the shareholders and 66% of the company management were Ukrainian. Therefore, under many treaties, it will be permissible to incorporate a company in a home state in order to invest in a host state. This means that investors considering foreign investment should carefully consider how to structure projects in order to maximize their treaty protection. With any corporate structure, there will be tax consequences, which must also be considered and which should certainly not be forgotten. Indirect investments generally qualify. For example, a home state company holding a minority stake in a host state company. An example of this is in the case of CMS against Argentina. A US company held a 30% stake in an Argentinian utilities company. The tribunal found jurisdiction where a treaty's definition of investment includes equity, stock, or shares in a company. A minority shareholder has a direct right of action against the host state that can be asserted independently from the rights of the company itself. However, tribunals may not recognize jurisdiction under BITs, bilateral investment treaties, where a reorganization, corporate reorganization, occurs after the investment has been made and once the dispute has arisen or is anticipated. In the case of Philip Morris Asia Limited against Australia, where Philip Morris reorganized to incorporate in Hong Kong in order to challenge tobacco legislation. In this situation, the tribunal found this to be an abusive process. A common way investors structure projects to secure protection from investment treaties is to have layers of shareholding in various jurisdictions. This has been a successful way of widening the range of possible investors, as tribunals have traditionally extended the interpretation of investment to include indirect shareholdings through an intermediate company, or even to allow claims from the ultimate beneficial owners of a corporate structure. So what are the protections? There are quite a few different sorts of protection, but there are really 3 classic protections under the investment treaties. First, the host state will not expropriate the investment without the payment of prompt, adequate and effective compensation. The host state will not subject investments to treatment less favorable than which it accords to investments or returns of its own investors, or to investments or returns of any third state. The host state will ensure fair and equitable treatment of the investor and afford its investment wider protection, generally based on expectations of the investor and promises of the state. In waste management against Mexico, a NAFTA tribunal, this is in 2004, defined fair and equitable treatment as being breached where conduct is arbitrary, grossly unfair, unjust, or idiosyncratic, is discriminatory, and exposes the claimant to sectional or racial prejudice, or involves a lack of due process, leading to an outcome which offends judicial propriety. The final protection has proved to be the most controversial, and many states are now removing it from future treaties or renegotiating old treaties to remove the protection and give the state more flexibility in order to reduce the risk of these enormous awards, which can be awarded in investment arbitration. More recent developments in investment treaties, there have been retreats from the height of investment treaty protection in three main ways. Restrictions on what qualifies as an investor. For example, the new Netherlands model BIT requires a legal person incorporated under the law of the relevant state to have substantial business activities in the territory of that state to qualify for protection. This is likely to reduce the opportunities for treaty shopping in future. Investors should be wary of attempts to renegotiate treaties relevant to their prospective investments. You've got to keep an eye on this, especially in the run-up to making an investment in some of these more challenging jurisdictions. There's also withdrawal from treaties and the ICSID Convention. Venezuela, Bolivia, and Ecuador have left the ICSID Convention. A number of agreements continue to be terminated, with at least 24 terminations coming into effect in 2018, including 12 BITs terminated by Ecuador and 5 by India. Fortunately, treaties usually have notice periods for withdrawal or change, often 12 months, in addition to continuing to apply to existing investments for 10 to 15 years post-termination. There's also a scaling back on the protections offered by these treaties. Various states are amending or replacing old-style BITs with more modern versions, which tend to reduce the protection of fair and equitable treatment, reduce or limit the right to dispute settlement, and to emphasize exceptions for environmental protection and other state interests. Many treaties now require an exhaustion of local remedies before commencing arbitration, and tribunals have been willing to enforce this requirement of state consent to arbitration. For example, the US, Canada, and Mexico have scaled back protections and access to dispute resolution under NAFTA, under the current US MCA, largely cutting protection against indirect expropriation, protecting the state's right to regulate, and requiring proceedings in the national courts first. So, in conclusion, ladies and gentlemen, there are plenty of advantageous ways to structure an investment and to mitigate risk. But remember, read the treaties, look out for useful foreign investment laws and investment agreements, and structure the investment before the investment is made in order to avoid problems. And lastly, make sure the structure is tax efficient. Thank you very much, ladies and gentlemen. It's been a pleasure speaking to you this evening from Australia.
Thank you very much indeed, Stephen. Another fascinating perspective on how the balance is being struck between the obvious need for economic development in various parts of the world and the appropriate regulatory requirements and protections. Now, some of you may have noticed that coincidentally, and I'm sure it was coincidentally, during the course of your presentation, Stephen, our first speaker, Colin, unfortunately dropped off the call. And I'm told that the reason is, and he did mention this when we were talking before we started, that in Western Australia, where he is also based, as well as our colleague Stephen, where Colin is based in Western Australia in Perth, a big storm was brewing. A relevant point, not least because we're about to hear from our environmental specialist in a moment or two. And the storm apparently has caused Cole's Wi-Fi to crash. And so that's why he hasn't been able to rejoin. I'm told that he will be trying to rejoin by phone if he can, and we very much hope that we will at least hear him, if not see him, later on for the purposes of questions. But in the meantime, if we may, we will press on, and I will hand over to Chris Badger to give his presentation. Chris, over to you.
Thanks, Stephen. Well, environment-related disputes by their nature involve a tension and at times a direct conflict between competing obligations of the state to, on the one hand, promote foreign investment, and on the other hand, to protect its population and territory from environmental harm, whilst responsibly managing its natural resources. Currently, there appears to be significant investor demand to direct more capital towards climate transition investments in developing markets. For Africa, that can be a positive, but it also creates this tension. Africa contributes just 3% of global emissions, but it is disproportionately affected by climate change, for example, by floods or droughts. But whilst institutions may not immediately want to finance projects that create emissions, it may actually be necessary to do so. By way of example, Africa's electricity grids are weak, and there is a need for an increase in electricity generation, and that is almost certainly going to lead to a need to increase emissions by creating electricity from non-renewable sources. Put simply, renewables are unlikely in the short term to be a complete answer to Africa's need to generate power. But with that broad thought in mind, I thought I'd concentrate on just a few environmental and legal topics that are relevant to and apply to large infrastructure projects in developing nations. Firstly, compliance with domestic environmental law. Secondly, the S in ESG, before finally, the international move towards sustainable development and emissions reduction. So, domestic environmental law. An investor is likely to be obliged to comply with the domestic laws of the host state governing environmental protection. That can be explicit in an investment contract, or in the applicable bit, may require that an investment be made and maintained in accordance with host state law. This can be a precondition to an investor being able to avail itself of the dispute settlement mechanism. In Metaltech Limited against Uzbekistan, the tribunal came to the conclusion that corruption was established to an extent sufficient to violate the law in Uzbekistan in connection with the establishment of the claimant's investment in that country. As a consequence, the investment had not been implemented in accordance with the laws and regulations of the contracting party in whose territory the investment was made, as required by the treaty. Uzbekistan's consent to ICSID arbitration, as expressed in the treaty, was restricted to disputes that concerned an investment, and that included only investments implemented in compliance with local law. Accordingly, the tribunal lacked jurisdiction over the dispute. The same result arose in October 2018 in Cortec Mining in Kenya, where investors had failed to comply with the provisions of Kenyan law, requiring an environmental impact license to be issued before the valid grant of any mining license. But critically in that case, the bit in question did not include express wording requiring investments to be made in accordance with host state law. But nonetheless, the tribunal found that this could be implied into both the interpretation of the bit and the ICSID Convention. Alternatively, even where jurisdiction is established, parties that infringe on environmental standards risk counterclaims for environmental damage. One example is Burlington and Ecuador. The principal claim in the case concerned an allegation that Ecuador had unlawfully expropriated Burlington's investment associated with oil exploration and exploitation. But the case is interesting from an environmental perspective because Ecuador launched a counterclaim for millions of dollars relating to soil cleanup costs, groundwater remediation costs, groundwater studies, and the costs of abandonment of wells, as well as damages and interest for a failure to return infrastructure in good condition to Ecuador. The counterclaim was resisted, partly on the ground that it was alleged to be a fabrication. But broadly, the tribunal found that the Ecuadorian constitution established strict liability for environmental harm. Fault was not a requirement, and Burlington could not raise an argument to resist liability on the ground that it had acted diligently. Under the strict liability regime, causation was presumed. That meant that Burlington could only be exempted from liability if it proved that harm was caused by a force majeure, a third party, or by Ecuador itself. Ecuador could not sustain an argument that full reparation or restoration mandated a return to pre-human conditions. Environmental harm was to be defined by reference to regulatory criteria, and an oil field operator could not be considered to have caused environmental harm if permissible limits had been observed. But the tribunal held that under Ecuadorian law, any exceedance of applicable limits triggered extra contractual civil liability and an ensuing obligation of full restoration back to those limits. And following a side-by-side analysis, the end result was that Burlington were found to be liable towards Ecuador for the cost of restoring the environment in the 2 oil fields that were the subject of the dispute, in the amount of $39 million US, and for the cost of having to remedy the infrastructure, another $2 million. And that was offset against the amount owed to Burlington by Ecuador itself, over $300 million. The flip side is that states also have obligations relevant to environmental law. In Burlington and Canada, the majority of the tribunal concluded that Canada had violated certain of its NAFTA obligations when a federal provincial environmental assessment panel recommended that Burlington's proposed quarry and marine terminal project in Nova Scotia should not go forward. Based on the findings of the assessment, the federal and Nova Scotia governments refused to approve the project. The tribunal's finding of liability was based on the conclusion that the environmental assessment was not carried out in accordance with applicable federal and provincial legislation. The majority's liability finding was also based on its determination that the assessment was carried out in a manner that did not comply with the level of procedural fairness required by Canadian administrative law, and it breached the requirement for fair and equitable treatment of the investors without justification. The end result was an award of $7 million as compensation to Burlington. Now, that might be considered an unusual decision. Ordinarily, a high degree of deference is given to a respondent state where they've regulated on the topic of the environment. But nonetheless, this decision and arguments put forward in another but ultimately unsuccessful claim called Allard and Barbados, which was namely that the state had not taken adequate measures to prevent environmental degradation impacting on its investment in an ecotourism facility. Both do highlight the importance of a state properly considering its own environmental obligations. The S in ESG. From a finance perspective, within Africa, more often than not, it's the S, the social, of ESG that is the most important, that social impact. Obtaining the relevant planning and permits may not be the biggest hurdle. After all, these are countries that have the space to accommodate large infrastructure projects and are desperate for work and income, and the promise of both as a consequence of a major infrastructure project will be appealing. Nevertheless, the consequences of failing to engage with local communities likely to be affected by the project can be severe. In Kinangot Wind Park Limited against the Republic of Kenya, one particular wind farm project just outside of Nairobi was cancelled after opposition from local landowners and farmers. A claim was made against the government of Kenya on the basis of a letter of support that had been issued by the government, in which the government promised to indemnify the company for losses suffered if the project was prevented because of political events. The award isn't actually publicly available, but it is possible to discern snippets from internet reports. The claim alleged that the government had failed to eliminate a political event emanating from community protests. But insufficient outreach efforts were at the root of the protest. The claim failed, as the relevant company failed to establish that the protests were a political event within the meaning of the letter of support. There'd been little or no community engagement, and issues had arisen over compensation, relocation, and the manner in which the land is leased. And arguably, the lack of community engagement meant that the company could not rely on the protections from the government. Turning to international environmental law. Traditionally, it can be difficult to establish legal rights capable of enforcement against non-state actors by virtue of international law. In the context of a counterclaim based on international human rights law, the tribunal in Urbesa versus Argentina held that the investor could, in principle, be bound by international human rights obligations concerning the right to water, and therefore it could be argued that investors are also directly subject to obligations arising out of international environmental treaties. But the difficulty with this argument is that most international environmental treaties, which address the activities of non-state actors, assume that state parties will establish a domestic institutional framework for their operationalization, meaning you can't turn to the treaty for direct obligations. However, that was before Friends of the Earth Netherlands took on Royal Dutch Shell in the District Court in The Hague just a couple of days ago. The day before yesterday, the Hague District Court held Shell to be in violation of the standard of care under Dutch law and ordered that Shell, both directly and through the companies and legal entities that form the Shell Group, reduce emissions by a net 45% across both emissions from its own operations and emissions from the use of the oil it produces. The court made its decision provisionally enforceable, meaning that Shell will be required to meet its reduction obligations even as the case is appealed. The court held that the RDS reduction obligation ensues from the unwritten standard of care laid down in Book 6, Section 162 of the Dutch Civil Code, which means that acting in conflict with what is generally accepted according to unwritten law is unlawful. The court concluded that the standard of care included the need for companies to take responsibility for Scope 3 emissions, that is, all other indirect emissions that form part of a company's value chain, including those that result from the use of sold products, especially where these emissions form the majority of a company's CO2 emissions, as is the case for companies that produce and sell fossil fuels. The court gave Shell flexibility in allocating emissions cuts between Scope 1, 2, and 3, so long as in aggregate, the total emissions were reduced by 45%. And the court wrote that it remains to be seen whether other companies will substitute Shell production in the face of Paris Agreement obligations, and noted that the causal relationship between production limitation and emissions reduction. The court wrote, the court acknowledges that RDS cannot solve this global problem on its own. However, this does not absolve RDS of its individual partial responsibility to do its part regarding the emissions of the Shell Group, which it can control and influence. Now, the decision is likely to be appealed, and it might be argued, given the Dutch code, that it's highly fact-specific. Nonetheless, one can sense the direction of travel. Following this decision, and that of Agenda, another Dutch case that concerned the duty of care owed by a state to its citizens in light of the danger posed by rising emissions. There is a rising tide requiring states and private companies to reduce global carbon emissions. Decisions such as that in Shell will fuel investors' desire to invest in climate transition investments in developing markets, and it will put them off investing in projects that will contribute to the production of carbon emissions. For the solar salt project, that may well be a good news. But as already identified, it isn't necessarily all good news for African prosperity and development. Developing markets need to balance investment and environmental benefit. Committing to net zero risks depriving developing markets of that opportunity to develop. Thank you.
Thank you very much indeed, Chris. And it's a delight to be rejoined by Col. And thank you very much for overcoming the local climatic conditions in order to enable you to reconnect with us. Now, we do have a few questions, and I'm going to put these to the speakers. Coincidentally, one question for each of you, but anyone can join in at this stage, and I'd certainly encourage general debate. Let me start with Col, just in case he gets cut off again, because somebody is interested in the investment side of this and wants to know what you think is likely to be the biggest challenge in trying to sell a project such as the one that you've very graphically described to us. What would be the biggest challenge in selling that project to potential investors?
The biggest challenge is not the project itself. The project is a terrific project. It's location, location, location. And I think it's people's perception of that part of the world. I mean, I'm a veteran of Africa, and I've been there, you know, working in there for probably 25 years and lived there for a decade. But, you know, I don't see it as a really difficult place. When you're actually on the ground there, of course, you don't see it as difficult. But I think to an outsider, you know, an outside investor, it's the location of the place, just the pure name of Somalia, but not Somaliland. So I think that's our biggest challenge, is not the project. The project's a great project. It's purely location, address.
Yes, thank you. Coincidentally, we've got a sort of supplementary question from a member of the audience, I think, who I'm not sure whether this colleague heard the very early part of your talk when you were describing the locality. But the question is, in what region is the plant located? Maybe the question is, where, you know, can you be a bit more specific as to where the plant is going to be?
All right. Well, Somaliland is the westernmost province of Somalia, now claiming to be independent. So it borders Djibouti. Now, the project is on the coast, runs east-west on the Gulf of Aden. And from the west is Djibouti, and to the east is the port of Berbera or Berbera. Now, if you have a look on the map, it's between Berbera, halfway between Berbera, the port, and Djibouti itself. So it's on that northern coast. In fact, there is only one coast. There's only a northern coast in Somaliland. So if you're looking at the map, it's simply the horizontal coast on the north.
Yeah, the questioner comments that since his wife comes from that particular region, coincidentally, then it follows that he's lived there himself for a number of years, and that's
okay. Well,
interest. And
if your
go ahead.
I beg your pardon.
No, go ahead.
If your colleague knows, then the village of Lubaya, that's where it is,
Right.
near Lubaya.
Well, let me mention that hereafter, if the two of you want to get together, and he describes the area you mentioned as a beautiful area, if the two of you want to connect, you can do so easily via Bridget, whom everybody will have been in touch with in order to join the webinar, and you can set up an email dialogue in that way if you wish to do so.
Be my pleasure.
So thanks very much for that little session, which was fascinating. Now, there is a question for Stephen Walker about investment protection. And the question is whether, in your view, investments overseas generally should be structured around the best available treaty protections. What's your thought about that?
Well, ladies and gentlemen, you'll be surprised if I say absolutely, definitely. The investment treaty regimes can actually provide you with some very impressive remedies, very impressive tools, not just to advance an arbitration to the bitter conclusion, but actually to put your clients in the best possible position, the best robust position to get a negotiated settlement as soon as possible. So these are great remedies. We lawyers love these sorts of remedies, and they're particularly good if the contractual remedies aren't so impressive, or there's other problems and so on. These sorts of remedies can really help you in a jam. So yes.
Thank you. Now, another supplementary question prompted by these comments, and I think this might be either for Stephen or for Cole to answer. How will such investment change the local community? For example, to take another extremely interesting part of the world, for example, the Middle East. Would you like to consider that? Shall we go back to Cole for that one first, and then ask Stephen to follow on? Cole, how about the impact on the local community, and somebody else says the annual benefit to the local economy. And how would you address this in the context? Or have you been involved in anything similar in the Middle East?
Yes, the effect on Somaliland and even Somalia is quite a lot. We would increase the GDP in Somaliland by something like 28%. The employment on the construction phase of the project would probably employ 1,000 people, but and reducing as the project progresses. However, as the civil engineering project gets smaller, the agricultural side gets larger, and the agricultural side is looking at employing probably up to 3,000 people. So for a project of that size, it's pretty good. The flow-on effects is probably 8 to 1 on that side. So for every person who's employed, probably 8 people, including that one person, another 7 people, if you like, are affected and benefit from that particular project. So on a local level, it has an enormous contribution. Further down the line, as one of the major exports of the region is cattle, there is a lack of feedstock. And also this agricultural project creates feedstock as well. So that'll certainly help the cattle industry, as a bonus. So an enormous thing. The development banks have been looking at this. It really ticks all the boxes. Economic well-being, downstream benefits, employment, you name it. It's all contributing enormously to such a small economy. That's all.
Just a quick supplementary from me. I think you mentioned that one element in the the project relates to potash. Is that right? And
yes, sulfate of potash.
Yes, and what would be the ultimate destination of that, or the ultimate use of that particular component?
If anyone can use it locally, that's fine, but it will probably, and we're aiming to export it across the border into Ethiopia. So the sulfate of potash is a high-grade fertilizer, which is suitable for fruit trees, nut trees, coffee, that sort of high return agricultural product.
Yeah.
So it'll probably go across the border into Ethiopia.
Thank you. Now, we've also had a question for Chris, and the questioner wants to know, with regard, I think, to a project like the solar salt project, what would be the most relevant environmental issues arising there, and how would you see those environmental issues arising as the years go by?
Well, I think it's probably twofold. I think insofar as it exists, compliance with domestic environmental law is critical. But secondly, I mean, the social element, the engagement with the local communities, the being able to communicate to them the environmental as well as the financial benefits of the project, and engaging with them seems to me to be absolutely crucial. I mean, in Kinangop, a huge loss resulted from failing to engage with the communities in the most effective way. And so those would be the two that I'd highlight.
Thank you. We have another question about the project from a member of the audience, Cole, who would like to know whether all the construction elements have already been awarded, or is there, says the questioner, still an opportunity to get involved?
There's very much an opportunity to get involved. As I mentioned earlier, we're going through the DFS stage, which is the definitive feasibility study stage. Now that stage includes all the design of the whole project, the engineering design and everything. So yes, as soon as the DFS is finished, we will be getting finance of $450 million US for the construction of the project. and no contracts have been let to date.
Thank you. So I suppose that once again, I can extend an invitation to the questioner to get in touch with you by any appropriate means, but certainly via Six Pump Court, via Bridget, we'll be happy to put the two of you in touch. And,
That'd be great. I look forward.
That dialogue can be taken forward. Right. Well, it's been a fascinating hour. I think that probably exhausts our time and possibly exhausts intellectually our speakers too. So I'm going to bring things to a conclusion. I see that the gentleman who has family connections, Cole, with the local area, has provided us in the chat with his email address. And so if somebody can either write that down or save it, then we will have his email address. But in the meantime, on behalf of the audience, and I include myself for this purpose, I'd like to thank all our speakers for their fascinating presentations and for their willingness to respond to questions. I'd like to thank the other members of the audience, apart from me, from joining us and from listening to what I hope you have found to be both informative and enjoyable. This is, in a sense, part of an ongoing series of webinars that we are hosting with an environmental theme, because one of the key topics in our chambers, apart from arbitration itself, is environmental law. So these webinars that we're arranging this year do, most of them have an environmental theme, and there will be more. So please do join us again. Anybody who's joined and others who may have expressed an interest but in the end not joined will receive information from us. You will receive the recording, I think, and any papers that are produced. And we very much look forward to you joining us again. But in the meantime, wherever you may be in the world, and whatever plans you may have for what we here in UK hope is going to be a bright and sunny weekend, I'll bid you a very good day for now. Thank you.
Thank you.